MUHTASIB, am I pronouncing that right, versus MUHTASIB versus the doctor. I'm PERICHERLA. Can somebody help me with the pronunciations?
I'd use MUHTASIB.
Okay, I was close on that one. All right, very good.
Good morning, Your Honor.
Morning.
Eric Gifford appearing on behalf of the appellant, Dr. MUHTASIB. Both sides have presented extensive briefs on the issues before the court today. As you mentioned, this is a lawsuit that was brought by Dr. MUHTASIB against Dr. PERICHERLA, the appellant, and her PA, which was as a result of an agreement between both doctors to start an OBGYN practice. My client purchased or bought into that pursuant to a number of agreements that were executed between the parties. The parties essentially executed a share purchase agreement, and along with that a number of ancillary agreements, including a shareholders agreement, and each of them executed a shareholders employment agreement. They had a practice in Ocala, Florida that was operating for some time, and then as a result of a number of factors, most specifically the malpractice issues that were going on in the state and a number of other issues, they began to have disagreements and conflicts in terms of how to operate the practice. As a result of that, Dr. PERICHERLA took some actions. There's some disputed facts at trial regarding who did what, but the ultimate result was my client gave notice that she intended to effect dissolution of the practice. At trial, there were a number of issues brought by Dr. MUHTASIB, mostly addressing breach of contract claims and breach of fiduciary claims against Dr. MUHTASIB and the PA.
Could you talk to me a little bit about the breach of fiduciary duty claims?
Yes, Your Honor. The breach of fiduciary claims, there was one brought by Dr. MUHTASIB against Dr. PERICHERLA. There was also one brought by Dr. PERICHERLA against MUHTASIB. Most of those addressed actions taken on behalf of each shareholder that were, in Dr. MUHTASIB's opinion, in violation of either the contracts or in particularly her obligation of good faith and fair dealing as shareholders. Both parties owed an obligation and a duty to one another. The fiduciary claim by Dr. MUHTASIB was raised much later in the pleadings. This case was heavily litigated, heavily contested, and the fiduciary duty claim essentially was that Dr. MUHTASIB had improperly deposited funds in a separate account, and more importantly that after the dissolution she had engaged in what I'll characterize as some form of self-dealing by utilizing office equipment and leasing it to herself for a lesser value, which obviously impacted the dissolution proceedings.
Okay, so the legal theory was that there was a fiduciary duty between these two shareholders.
Yes, Your Honor. And I think the point of your question probably gets to our second issue regarding the entitlement issue, I'm trying to anticipate that. But
well, I'm just trying to understand the facts a little better because there's not much discussion in the briefs that I could find about the basis for the judgment that actually was. I mean, as I understand it, the jury only awarded like $8,100.
$8,100, Your Honor. Yes, and in
summary, that was on one of these breach of fiduciary duty claims.
Correct.
It was only against Dr. PERICHERLA, right?
That's correct, Your Honor. And
right, so,
I should clarify as well that the jury did return a verdict against Dr. MUHTASIB for breach of her fiduciary duty owed to Dr. PERICHERLA. However, they did not award any damages as a result of that. And again, the jury's determination was that neither party, either Dr. MUHTASIB or Dr. PERICHERLA or the PA, had breached any kind of contractual obligations to one another. The jury rested its verdict, if you will, on the breach of fiduciary issue, which led us to the appellate issue.
Okay, so explain this breach of fiduciary duty in terms of the facts that were presented at trial.
Presented at trial, Your Honor, Dr. PERICHERLA testified regarding a number of transactions that Dr. MUHTASIB testified a number of transactions that Dr. PERICHERLA had engaged in, most specifically having taken funds that belonged to the PA, to the shareholder practice, if you will, and deposited those in an account that had been isolated or separated so that Dr. MUHTASIB had no access to that, in effect cutting her off from funds or shares that were to be distributed amongst the parties. That was one action that was taken. The most significant one, I believe, was her actions post-dissolution, where she took the shareholder property, if you will, the property and equipment that belonged to the practice, and essentially leased it to herself for the sum of $500. And the jury found that that was inappropriate under the circumstances, that it did not fairly provide value. Understandably, I can't be a fly on the wall, don't know what kind of arguments or discussions were had in the jury, but the ultimate result was that they awarded damages to my client in the amount of $8,100.
What was the evidence at trial of damages based on this breach of fiduciary duty that your client claimed?
Again, the evidence, that was one of the disputed issues I know that the appellee has brought up in terms of nominal or monetary damages. And the only evidence that I could discern was, again, testimony, and admittedly it was conflicting as to what the effect of this equipment being leased back to Dr. PERICHERLA had caused. And that issue was admittedly not fleshed out. The court, though, in addressing their motion for directed verdict, indicated that there was some evidence, enough at least to entitle the plaintiff to potentially nominal damages on that issue, and therefore that issue was submitted to the trial. As to how the jury determined the $8,100, I would have to speculate, Your Honor.
Go ahead.
Let me get you to focus a little bit on the attorney's fee issue for a minute.
Yes, Your Honor.
Because that's really what, as I view this case, that's really what the case is all about, to be honest. But they cite this Fairway Royal Association versus Hassan Realty Corp. Tell me how you can distinguish that or get around that case. It seems like it might be controlling.
Well, Your Honor, the issue...
that was a lessee suit to collect rent, remember?
Yes, Your Honor. And the issue on the attorney fee issue, understandably, the entitlement issue is the most significant. I would point out to the court, I'm not trying to avoid this case, but one of the concerns that the appellant had was that the parties had stipulated regarding the reasonableness issue.
Regarding what?
Reasonableness of fees.
Okay.
And understandably, before we could get to, the entitlement issue is, I believe, as the court has pointed out, the most significant issue. That issue was heavily briefed and argued by both parties, both in February and then again in April of 2006 before Judge Singbush. And the difficulty, I believe, in the case is that the court reached a determination that my client was a prevailing party, but arguably did not elaborate on the methodology in terms of how he arrived there. Our client mainly has argued that the breach of fiduciary claim was inexorably intertwined with the breach of contract, or the claims under breach of contract, and for that reason the two are intertwined such that our client should have been determined to be the prevailing party. The case law in this case, Musselwhite versus Charbonneau, is a case that we've cited as support, and that was argued extensively before Judge Singbush in determining the entitlement issue. And our position was, again, that because the fiduciary claim had been raised without the contract or the contract and agreements between the parties, that claim itself could not be separated or distinguished between the two.
But aren't these interrelated theories of liability for a single wrong?
Are they interrelated? Well, the difference in Musselwhite, Your Honor, was there was a fiduciary claim that dealt with the specific performance claim. In that particular case, it was a contract claim. There had been some misrepresentations prior to that regarding, I believe, a sewage treatment plant that went with that property, and the court determined that those were different. I know that the appellee has argued that the fiduciary claim is a tort, can't exist independent of the contract claims. The Musselwhite claim, I believe we can support in terms of the facts. The facts of the case was there was a contract. There clearly was an obligation owed between the parties. And I'm not trying to broaden Musselwhite beyond the four corners of that case, but I know that appellee has argued, well, if you have a written contract, then you arguably have a fiduciary claim in every case that involves a contract. And that potentially is a valid argument. I can understand the court being concerned of expanding that doctrine such that we erase this distinction between the two claims. But I believe that Judge Singbush felt compelled that because the fiduciary duty was a derivative of the contract claim, and more importantly, without the contract, you wouldn't have that obligation, that he felt compelled that they were inexorably intertwined such that the entitlement issue determined that our client was the prevailing party. The concern I know for the court, we have a breach of fiduciary claim that doesn't have a statutory or a contractual attorney fee clause that goes with it. But again, the argument with the court was that because the shareholder agreement and the shareholder employment agreements all did have a contractual claim, that those two were so intertwined that there was a basis to find that our client was entitled to fees as the prevailing party. My argument addressed the reasonableness issue. As you know, Judge Singbush made a drastic reduction in fees, 50% essentially in the fees sought by my client. And which gets back to the stipulation issue. The problem in this case is both parties effectively stipulated to the reasonableness of the amount of the fees. And the issue we've raised on appeals, assuming we get past the entitlement issue, is that he just arbitrarily cut the costs or cut the fees without any justification.
The problem we have with that is that's an abuse of discretion standard,
Yes, Your Honor.
and it's difficult to get a court to say that the judge abused discretion on attorney's fees. I've tried it on appeal before, and I never got anywhere with it, and I think that's still pretty hard to do.
I understand, Your Honor, and understanding that standard review, it is an uphill battle, but I believe if you review the record, you will see a combination of factors, and I believe it was largely addressed or due to the stipulation between counsel for both parties. That stipulation essentially said that the amount of fees sought by either party was reasonable, and that's in the record at 858, 861, a copy of that stipulation.
The stipulation is between the parties is in no way binding on the trial court unless the trial court says, yes, I agree.
I understand, Your Honor, and it is not, what it gets to, though, is in terms of making that decision as to whether a results obtained analysis is appropriate. I don't believe that the court actually did that, Your Honor. I know that the judgment that was entered by the court says he's considered the results obtained and reduced it, but unless and until the court engages in that analysis, he hasn't done his judicial duty. Case law clearly shows that. I also recognize and will acknowledge
How do we know
to
that
the court.
He didn't?
I'm sorry, Your Honor?
How do we know that he didn't engage in that?
The issue is there was a February hearing where my client argued entitlement. There was an April hearing where Mr. Cooper argued entitlement. We know from the record because once the judge issued his decision that our client was entitled to fees, there were a number of, there's a letter in the record from Patrick Gilligan, plaintiff's counsel, stating that there seemed to be now a conflict after this hearing where Mr. Cooper now was arguing that his stipulation didn't mean what we believe it said it meant. And up to that point in time, the parties had agreed that this stipulation and the fees that were submitted were reasonable. That was the amount that both parties agreed were reasonable, did not require any kind of assessment. My client did not have an opportunity to go through the analysis to determine and prove, if necessary, whether the fees incurred in this litigation regarding the fiduciary duty were intertwined. It just never happened. And additionally, the court didn't allow additional evidence as to that, nor did it make any specific findings as to what amounts of fees related to one claim or the other. And the reason that wasn't done was because from the plaintiff's perspective, they were inexorably intertwined, and as a second part of the analysis, the fees related to the breach of contract claim also were intertwined with the fiduciary duty. You had to prove one to prove the other. The only way we know that the judge did this analysis, if he did, is because he said so in his final order. But we know from the record that it didn't happen. The last hearing essentially addressed entitlement. Once that was completed, there was some correspondence, and the judge, I believe, arbitrarily said it's half. And we also know that based on his treatment of the cost issue, which is a third issue raised by my client. Cost being essentially cut strictly in half.
I'm sympathetic to your argument, but if I had been the trial judge, I probably would have agreed with you. But unfortunately, we've got an abuse of discretion standard here, and it's hard to say that no reasonable circuit judge would do that.
I understand, Your Honor, and I understand standard on appeal, and obviously we're not here to retry the issues, and I know the judge's order says he did what he did. Our position then is essentially that reduction in fees was not appropriate, again, because having reached the issue of entitlement, assuming that position was correct, that at that point they were inexorably intertwined, and as a result, the fees that had to be as well.
Counsel, talk to me a little bit about this inexorably intertwined argument about the breach of fiduciary duty and the breach of contract. how are they inexorably intertwined?
Well, the issue that was raised in the briefs and at trial during the argument with the court was that the breach of fiduciary claim, if you look at the complaint, the amended complaint specifically addresses the shareholders agreement and the employment agreement. It says that this is essentially how we get to this breach.
Well, but as I understand what you were telling me was that the theory behind the breach of fiduciary duty claim was the relationship of the two shareholders, and the relationship that would have existed if there had been no shareholder agreement. If there, I mean, I just don't understand how they're not only inexorably intertwined, but how they even intersect.
And I understand your concern, Your Honor, and I think I addressed this briefly about the distinction between the two claims. You have a tort claim, you have a contract claim. If you look back at the Musselwhite case, by analogy, I could argue that in Musselwhite you had a real estate contract that involved the purchase of property.
Well, for good or ill, in that case, the breach of fiduciary duty claim did arise out of the contract. This one doesn't.
Our argument with that is the Cox case, and I know I cited that in my brief, that essentially says that every contract has this independent obligation.
Well, even if that's true, it's not actionable in Florida, and even if it were actionable in Florida, that's not the basis of your claim.
Yes, Your Honor.
So how is it that the trial court didn't err in finding that they were inexorably intertwined? I just don't understand it. I
understand, Your Honor. And again, the argument was made and Musselwhite was presented as a support for that position. And I understand your concerns. I have looked at it as well, but I certainly believe in that respect with the entitlement issue, I'm not willing to concede that it was error. And I believe the judge reviewed that clearly and essentially found that the fiduciary duty was connected to the contract. And I understand your concern.
All right, even if you assume for purposes of discussion that there's some intersection between the two claims, how is it possible not to be able to separate out the fees awardable on the two claims? They're completely, I mean, the proof is completely different.
Yes, Your Honor, and that's the issue. I tried to answer Judge Police's concerns because that is a requirement under the various cases dealing with this issue. There's supposed to be some analysis of the record, and again, I understand the abuse of discretion is a standard. That did not happen, and my client was never offered the opportunity.
But that was to your advantage.
Potentially. It depends on how you look at it, Your Honor. The reduction in half may have worked to our advantage or may have not. The law clearly required that analysis to take place. Admittedly, the burden under the case law is on my client to provide that analysis. I'm just representing the court. Based on the record, it never happened. The only proof that we have that it did happen is the judge's order that was signed saying, I engaged in this analysis, considered the results obtained, and divided it by half. The amount that my client's entitled to may be considerably less than what the judge actually awarded. I'll acknowledge that once you analyze the fee agreement. But the parties stipulated and they submitted affidavits, and Appellee's counsel has noted that we didn't present anything but the affidavits. And again, the reason for that was this stipulation that essentially indicated that the amount of fees was reasonable and was not to be disturbed by the judge or anyone else. That was stipulated by the parties. Now, the judge may have an independent obligation to go through and conduct this analysis, but he didn't do it. And I believe that was an abuse of discretion on his part for not engaging in that. And as a result, we believe that his decision was inappropriate. I know the other issue I have not addressed is the cost issue. I believe the case law is very clear on that in terms of statutory issues. And again, that dovetails or follows these other arguments. I would touch on as well the denial of our motion for directed verdict. I know Appellee's counsel, that addressed a dispute between the contract. The evidence at trial addressed this assessment of a management fee, $2,000 fee against my client that was retroactively assessed post-dissolution. The evidence at trial clearly showed that there were several agreements signed by the parties. The shareholder agreement, as I pointed out in my brief, had a number of specific requirements, conditions precedent, if you will, that before my client could be removed from her management duties, there had to be some violation that she had committed that was specifically laid out in the agreement. The employment agreement that was signed by both parties had a similar provision regarding management fees, but did not have these additional claims. What our position at trial was is that there was no evidence submitted by Dr. PERICHERLA that suggested that she had given proper notice, or that had been any kind of condition that would allow my client to be removed. The issue on that is I think the appellee argues that the only agreement we've alleged was breached was the 1 minute, I think, Your Honor, was the employment agreement. And as I pointed out in my brief, that issue was litigated at trial. The testimony and evidence from Dr. Mustabid indicated that both the employment agreement and the shareholder agreement had been breached. That was the testimony. No objection was made by counsel. Both parties, mainly Dr. Mustabid's counsel, moved to amend the evidence or amend the pleadings to conform with the evidence, which allowed both those agreements to come in. And our position on that issue is that, again, by Dr. PERICHERLA's own admission, there was no evidence to suggest that she was properly removed. There was a March 2003 letter that discussed only lack of communication or communication problems. And as a result of that, we believe that there's no evidence to support the jury's or the judge's denial of our motion for directed verdict. And on that issue, should we prevail, it renders most of these other arguments essentially moot, because we would have prevailed under the contract provision and be entitled to that. I see my time has ended. Thank you.
Okay, thank you.
May it please the Court, Angela Flowers on behalf of VARMA, PERICHERLA, P.A., and Dr. PERICHERLA individually. I will jump directly to the breach of fiduciary duty issue, because that has certainly been very difficult to understand in this case. What it was that Dr. MUHTASIB was asserting that Dr. PERICHERLA did wrong in terms of a breach of fiduciary duty. It's been made all that more complicated to understand because Dr. MUHTASIB's attorney during closing argument didn't address the issue to the jury and didn't give the jury any suggestion as to how they could possibly award damages against Dr. PERICHERLA on this breach of fiduciary duty claim. Now, in yesterday rereading the transcript, I believe that I have finally deconstructed what it is that Dr. MUHTASIB's attorney was attempting to do with this breach of fiduciary duty claim. And let me remind the Court that under Count 3, there were 4 specific acts which were alleged to be breaches of fiduciary duty. The first 3 acts had to do with the transfer of funds from the operating account to a Fidelity investment account. This was an account which was used prior to this partnership being formed and throughout the existence of this partnership, and as known to Dr. MUHTASIB, was an account used that when large sums of money were in the operating account, they would be transferred to the Fidelity account so that they could earn interest, and they'd be transferred back when they were needed. As to the transfer of funds back and forth to this account, the accountants clearly testified that it had no detrimental impact upon their ability to evaluate the assets of the corporation and what monies might or might not be owing to each of the parties, because the income of funds was first shown on the everyday ledger sheet. And the fact that the monies were transferred back and forth to Fidelity had nothing to do with the accountants accounting for those funds. So those funds were fully accounted for in the everyday balance sheet, and there were no hidden monies, which Dr. PERICHERLA was able to secret away from Dr. MUHTASIB, which was in fact her claim. Now, what gets further developed in the course of trial is an idea that because you're transferring these monies back and forth, you snuck something out of the account, and therefore now here we are 3 years later at trial, and the account has a zero balance, the operating account for the PA, and therefore I may get this huge judgment against you, and I'm not going to be able to recover anything from the PA. So let me file a breach of fiduciary duty claim against Dr. PERICHERLA, so I'll be able to go after her personally if she took monies out of the account and has now left them unavailable for me to recover my judgment against the PA. That was the theory. And it came up also in regard to the 4th element of the breach of fiduciary duty claim, which was where Dr. MUHTASIB claimed that it was inappropriate for Dr. PERICHERLA to lease the inventory assets, or their hard assets, to the subsequent corporation which Dr. PERICHERLA formed 5 months after Dr. MUHTASIB left. All right? What happened is that Dr. MUHTASIB left in July. At the end of the year, beginning of the new year, January 2004, Dr. PERICHERLA established a new corporation. And all of the hard assets, the machinery, whatever was part of the medical practice, was leased to this new corporation for $500 a month for a total of $6,000 a year. So when questioning Dr. MUHTASIB when Dr. MUHTASIB's counsel was questioning Dr. PERICHERLA, this is on page 669 of the trial transcript, he asked her, he's asking her, how did you come up with this number? It was given to me by my accountants. Well, he goes on to say, isn't it true that if in fact this number, $500, is all that's being collected per month, it would take the accumulation of funds for up to 14 years in order for my client to be able to recoup what she's owed for the repurchase of her stock. And that was one of the original damage claims. This really comes to light when Dr. MUHTASIB's counsel was arguing against our motion for directed verdict. We sought directed verdict on these breach of fiduciary duty claims. The judge granted directed verdict on the first two claims. There were 3 transfers back and forth to Fidelity. He knocked out the first 2. The third one, because it occurred in June after Dr. PERICHERLA had received notice that Dr. MUHTASIB was going to be leaving the practice, he left that element of breach of fiduciary duty in there. It has to do with a transfer of $100,000 in June. And he also left in there that claim that the assets were improperly transferred to the subsequent corporation. So then, during the discussion on the directed verdict issue, it begins on page 669, and it goes through page 672. And here, Dr. MUHTASIB's counsel explicitly explains to the judge what his theory of the breach of fiduciary duty claim was. And that was, in essence, that, because she's only charging $500 rent, it'll take 14 years for enough money to accumulate for Dr. MUHTASIB to recover on her judgment, assuming she got a judgment. Well, of course.
Is there any evidence in the record of what would have been a fair rental of the equipment?
There's evidence from Dr. PERICHERLA that, through the advice of both counsel and her accountant, that she was told that $500 a month would be a fair rental amount.
And there's no evidence from the other side that a greater number would have been.
That evidence was not impeached, nor was it contradicted. And when the accountant was on the stand, there was also no impeachment of him as to the subject was not brought up in regard to the accountant, when MUHTASIB would have had an opportunity to attack the accountant's advice. Okay? So that is, in essence, what's going on with the breach of fiduciary duty claim. That is also why we're asking this court to enter the directed verdict that the trial judge should have entered on this breach of fiduciary duty claim. There were no damages that were caused to Dr. MUHTASIB by either the use of the Fidelity account for earning investment interest, nor by the rental of the assets of this corporation after she left the partnership and left the country. Now, I want to just give you a very brief sketch of what the damages claim was in this case, so you will understand why it wouldn't matter what money was in the corporate account after December 31st. So you'll understand why there could be no breach of fiduciary duty claim the way they're making this, and there should have been a directed verdict on this. And in essence, what the claim was is that Dr. MUHTASIB brought suit in this case claiming that she had been involuntarily terminated. Conversely, Dr. PERICHERLA argued that no, you voluntarily terminated yourself and you did it without notice. So the question before the jury is, which was it? An involuntary termination or a voluntary termination without notice? The difference being that if it was, as Dr. PERICHERLA says, a voluntary termination without the proper notice, the contract provided that Dr. MUHTASIB would receive her salary up through the end of the month following her termination, and that then she would be entitled to have her stock repurchased. That's it. That's all the damages that she was going to get. And this is, in fact, what the jury found happened. But Dr. MUHTASIB was claiming that she had been involuntarily terminated, and that because she'd been involuntarily terminated, the contract provided that not only would she receive her salary up through the end of the month following her termination, but that she would also receive 90% of all accounts collected for the 12 months following her termination. So she was seeking a much greater award. And that's what her counsel was getting at when he was arguing, you know, he needed money in the PA's checking account so that if he prevailed on his theory of breach of contract, that in fact Dr. MUHTASIB was not only supposed to get salary up through the end of the month following her termination, but also 90% of accounts received for the next 12 months. He needed money in the account to be able to collect that judgment if it came in. As I said, the jury found that there was no breach of contract, that it had been a voluntary termination by Dr. MUHTASIB, and that she was not entitled to any damages, that she'd received everything that she was entitled to. And by the way, the reason she received everything she was entitled to is because she went to the corporate account and withdrew $43,000 on her way out of the country. So that's what ended up covering the salary that she would have been entitled to through the month of July and the month following her termination, August 31st. And that in turn was offset by what she would have been owed on the purchase of the stock, the repurchase of the stock. The repurchase of the stock was calculated in one simple way. The parties were to evaluate the value of the inventory, the hard assets in the office, and they were to divide it by 2. And Dr. PERICHERLA was to pay her the 50% of the value of all the assets. There was conflicting evidence at trial regarding the value of the assets. The jury apparently believed Dr. MUHTASIB's valuation of the assets, but that valuation was offset by the $43,000 she withdrew when she left the country. So, no one's appealed from the breach of contract actions, the claims on that, but I wanted you to understand what had been going on underlying the main theme of this case, which led plaintiff's counsel to come up with this theory as to why he wanted money in the account and why, if someone in fact had been removing money so it wasn't going to be available to collect the judgment, he had this theory that that was a breach of fiduciary duty. Now, I want to go back and address in order our issues, and I'm going to do it hopefully very, very quickly because I think that they're very straightforward as to what remains. In regard to the management fee that Dr. MUHTASIB was seeking and that she's asking this court to direct a verdict on, that management fee arose under one of the 2 different contracts. We have an employment agreement contract, which has a management fee provision. And it basically says, we're going to take turns managing the office. But if one of us can't do it during their turn and the other person has to step in and do it, you're going to be charged a management fee because I had to step in for you. Then there's a shareholders agreement contract. And it had a much different management fee provision. It was a management fee provision to protect the corporation in the event that one of the doctors, while they were managing the business, engaged in improprieties. So we have 2 completely different reasons for why there might be a management fee charged. The jury was told about both of the different reasons. They were told about both of the contracts. And the jury was clear that Dr. PERICHERLA wasn't claiming any improprieties happened in this case. She wasn't trying to implement the formal procedures that would have been required under the shareholder agreement to take back management. Rather, she was going under the employment agreement, and she simply stepped in when her partner was not in a position or was not willing to manage day-to-day affairs in the office. And the employment agreement provides for that. The jury was entitled to find that the employment agreement was the only applicable agreement to this management fee. Disregard the shareholders agreement because there's no claims of impropriety. This is merely a stepping in when your partner can't handle the situation. So there's no grounds for a directed verdict on that. The jury had ample evidence, including evidence from Dr. MUHTASIB. On pages 302 to 03, she acknowledges, she reads the provision to the jury. She acknowledges that it exists and that that's one way that a management fee can be charged. All right, as to the attorney's fees were awarded in this case against Dr. PERICHERLA individually on the breach of fiduciary duty claim. Now, of course, if this court directs a verdict on the breach of fiduciary duty claim, then the attorney's fee award goes away completely, and we don't have to get into the nuances of what happened with the attorney fee award. And I do think that that is what the outcome should be, because there was no valid reason for sending this breach of fiduciary duty claim to the jury. But looking at what the trial judge did with what he had in front of him, Dr. MUHTASIB sought attorney's fees on a tort claim. and came up with this theory that this tort claim was so inextricably intertwined with the contract claims that she should be able to go under the contractual provision in order to recover attorney's fees on the tort claim. Now, I want to start first with just the fact that when you look at the language of this contractual attorney fee provision, it states that in the event of litigation under this agreement, and I would suggest to this court that this claim for breach of fiduciary duty was not litigation under this agreement. So by the very terms of the attorney's fee provision, it would not apply. It could never be applied in order for them to recover attorney's fees for the breach of fiduciary duty. Next, I want to also point out to this court that the trial judge could only reach the award which he entered by finding that the tort claim and the contract claims were inextricably intertwined. I likewise can see no way in which these claims intersect, much less become inextricably intertwined. As I've described the breach of fiduciary duty claim as it was advocated by Dr. MUHTASIB's counsel at trial, this is a claim that has nothing to do with the contract. The idea that a partner might be doing something to remove monies from the corporate account so that they wouldn't be available, or even just to remove monies in general, that is outside the contract, and it cannot be said that it is a negligence that is similar or the same as those acts which were involved in the breach of contract claims. So it's our position that the trial judge was incorrect in even finding that there was entitlement. So if there's no finding of entitlement, then there should have been no award of attorney's fees at all. However, if we do look at the award of attorney's fees, I want to say that the trial judge clearly did not abuse his discretion if he didn't make a mistake about entitlement, if he didn't make a mistake about directed verdict on breach of fiduciary duty, and if he was going to be able to award fees, it can't be said that it was abuse of discretion for him to have reduced this fee amount. The stipulation has been mentioned to you. I want to point out that there was a stipulation between the parties in regard to the need to bring live witnesses in to testify at the attorney fee hearing. The stipulation had to do with the parties accepting that the fees sought by each side were reasonable to the extent that they printed out their timesheets, they had expert witnesses who submitted affidavits that attested to those timesheets. So it was a stipulation designed to not need to go beyond the affidavits. And that's actually the reason that we have not been able to appeal from the trial judge's determination of the lodestar number, because of that stipulation. Okay? That stipulation went to the judge's ability to determine the lodestar number. But we didn't make any stipulation in regard to the duties that faced the trial judge once he determined the lodestar number, and he had to apply the Roe factors in order to determine what was a reasonable attorney fee in this case.
Was there a specific amount that was ever agreed to or not?
No. It went to the affidavits, and that there wouldn't have to be any live testimony beyond what the affidavits saying these were reasonable attorney fee awards.
Isn't there kind of an implied agreement between the parties, though, that these are the facts, these are our timesheets, these are opinions, and leave it up to the judge to set it based on that?
Well, that's hard for me to say because, it's trying to read beyond what's just on the face of the documents. Because there was argument from Dr. PERICHERLA's counsel before the trial judge that he needed to still determine what was a reasonable amount of the fee. So that argument was advanced to the trial judge, despite the fact that they had this stipulation regarding the number and the experts' testimonies.
I just got the impression that both parties were comfortable in submitting all of this information to the judge and letting the judge make up his mind.
As to the lodestar number, yes. I'm not disagreeing with that, and as I said, we haven't tried to contest how he determined the lodestar number. But there was still the request made of the trial judge that he had to determine what was a reasonable amount in light of the blanket numbers that were presented to him. So at that point, the judge was entitled to look at the amounts that were involved in this case and the results obtained. And in doing that, I believe that it cannot be said he abused his discretion in reducing it by 50%, since all that Dr. MUHTASIB prevailed on in this case was the breach of fiduciary duty claim. She lost on her 2 breach of contract claims. In regard to the reduction for the cost amount, I'm just going to say simply that the statute provides that costs shall be awarded, but it doesn't provide that the trial judge shall award every dime requested. The trial judge makes an intelligent evaluation of what are reasonable costs. And again, I don't believe it can be said in this case that he abused his discretion, especially when you note, if you look at the cost, the itemization of costs, one of those items is a $14,000 expert witness fee that would have had nothing to do with the breach of fiduciary duty claim. I want to point out that we've also appealed the fact that attorney's fees were not awarded to Dr. PERICHERLA. And it's probably the last point that I'll be able to get to, but I just want to make it clear, Dr. PERICHERLA was sued individually for breach of contract and breach of fiduciary duty. She did not file any counterclaim. She prevailed on the breach of contract claim. Under the contract, she is clearly the prevailing party, and she is entitled to an award of attorney's fees. And I'd like to point that out to this court because I think it's very important that that get cleared up at this stage. Appreciate your attention and concern about the case, and I ask that you make those determinations as outlined in the brief because there are multiple alternative reliefs which are sought. Thank you, Your Honors.
Thank you both very much. Well argued on both sides.